Hey, good morning. Akwadi. Nice to see all of you. So we'll get started because we have a lot to talk about and we have an hour to do it, but hopefully folks will come in and out. I'm Laura Vitaro. I am an arbitrator and a mediator. I practice in Providence, Rhode Island, and I sit on panels for the American Arbitration Association. We have some folks here today from AAA, which is a sponsor of the conference today. And I also sit on the board of the Center for Mediation, and we have folks from the Center for Mediation here today. And we're here to talk about sharing some information on two processes that we use to resolve disputes in the American legal court system, but they're actually used outside of court to resolve disputes: arbitration and mediation. And I guess I want to start by saying I would be remiss if I didn't acknowledge, after sitting through several sessions yesterday, the raw emotions that I heard that often come about in complex legal situations, the hurt and the injustice and the anger and the distrust. And I just want to acknowledge that and acknowledge that I know there's a lot of distrust of the American legal system. And so the folks at CIPR asked us to come and share information about methods that we are all involved in that help parties resolve legal disputes in a way that is outside of that system, but lets parties share their stories and their emotions and heal in some ways, move through those processes in a productive way to reach a legal outcome that is actually legally binding. And we're going to get into more specifics about that. Arbitration and mediation are very different, and you're going to hear about those, but I think the common theme is that they're both much less formal than being in court, and you, as the parties, get to choose who your neutral is. Very different from being in court where you don't know who the judge will be. And while we as a panel, other than Jennifer with CIPR, don't know peacemaking, tribal peacemaking, what we understand is that mediation might be the closest thing to tribal peacemaking from the American legal system. So we asked Jennifer to join us to, as needed, comment on that, the peacemaking side of things and how that might be similar or different than what we're presenting. So we hope that what we're presenting today just sparks some conversation. We invite your questions. We're only going to be able to give you a taste in an hour of what these processes provide. We welcome your calls later if you want to follow up and talk more about this. So I'll start with Jeff to my right to introduce ourselves.
I'm Jeff Zano. I'm with the American Arbitration Association, a proud sponsor of this event, and thank you for having us. I'm with the American Arbitration Association. I've been with them for about 30 years. I oversee the commercial division in New York City.
My name is Jennifer Rigo. I'm the Director of ADR Services for the Commercial Division at the AAA. My office is actually in Boston. However, I do a lot of work in New York and Rhode Island as well.
I'm Elizabeth Corsetti. I also am from the American Arbitration Association.
A lot of us here.
We're representing. So I have been with the AAA just under 10 years. And I actually, we have like a case administration center that is in Johnston, Rhode Island. So we have a group of about 50 people who I manage, and we actually do all of basically the majority of the arbitrations kind of up and down the eastern seaboard, so from like DC up through New England, Michigan, which is kind of random, and a couple of other states. So yeah.
Thanks.
Good morning, everyone. My name is Tricia Driscoll, and I'm the Executive Director of the Center for Mediation and Collaboration, Rhode Island. We have the longest name imaginable. Sorry about that.
We do.
We're Rhode Island's only community mediation center. We're a nonprofit, and we focus on training, educating, and mediating. And our goal as a nonprofit is to empower other people to resolve their own conflicts. So we do a lot of training. We do a lot of mediation ourselves. We provide volunteer mediators in the Rhode Island district courts to help people, as Laura said, try to resolve their conflicts without having a judge decide for them. We find that most of us kind of deep down don't want other people deciding for us. We want to be part of that solution. And so that's really helpful for us. We also have a very large presence in the agricultural community. We have a number of programs, including a program called Land and Sea Together that focuses on supporting the mental health and wellness of farmers, fishers, and foresters in the state of Rhode Island. So we're very grateful to be here. We believe strongly in the empowerment of people to resolve their own conflicts. So that's why we're here today. So thank you.
And I'm Jennifer Rollins. Most of you know me. I'm the co-director of the Center for Indigenous Peoples' Rights. I'm going to share some perspectives on peacemaking, but I have many elders and dignitaries from my own community here in the room, and I always defer to those community members on their knowledge and experience. Thank you for being here.
Thank you all. Okay, so this is going to be just a roundtable discussion. First, let's start with introducing the concepts. Elizabeth, why don't you tell us about what is arbitration?
Okay, so there's sometimes some confusion. So mediation is 100% like party driven, right? So the parties, they come together, they will work with a neutral who can kind of help them get to a settlement. And if you compare that to arbitration, which actually mirrors court in a lot of ways, there's a neutral that the parties do have some say in the matter about who they select. But ultimately that arbitrator acts like a judge. So whatever ultimately their decision is binding in the end. There's a final award. So really, I mean, we're also, and I kind of failed to mention that the AAA actually is a not-for-profit. And we actually really encourage parties, even if they are in the arbitration process, to think about doing mediation, right? Because at that point you can preserve relationships, and which I think is like super important. And you also have a lot more say in the outcome versus just making your arguments to the arbitrator who's going to make a decision. Arbitration differs from court in that it's just not as formal. All the sort of rules of evidence don't necessarily apply, so it's a little more flexible. It usually moves quicker than court. What am I missing?
No, yeah, you're 100% right.
Okay.
I mean, I think on court, it's like on average in court, it's like 2 years, and some complicated cases for AAA, 6 months to 9 months sometimes. And you're an arbitrator, some of your cases probably are done within months.
Right, yeah.
Compared to going to litigation, which is awful. If anyone's been in litigation, it's terrible.
Yeah. Yeah, so the goal for arbitration is to be more efficient, quicker,
Cheaper, more cost effective.
Also, I found as an arbitrator, you can, because you're not bound by the rules of evidence like you are in court, you can allow in more evidence, and it's up to the arbitrator to rely on their background, knowledge of the law, experience to determine what's relevant to making the decisions on the award, but a lot more flexible in how evidence is presented. I think witnesses are given more latitude to kind of tell their story and talk a little more freely than would they be subject to the rules of evidence if they were in court. Mm-hmm. What about the setting of an arbitration? What does that look like?
So and that really can be, it's interesting because since COVID, we do actually a lot more arbitrations that are virtual, which provides a lot of flexibility for people, or they might be some kind of hybrid, right? So you might have, an arbitrator sitting in a room with like one of the parties, and then a witness is able to kind of stream in virtually, and it's not in court. Typically we have offices that parties can use. A lot of times it's maybe where the arbitrator has an office, so it's a little less formal than being in court.
But the arbitrator still takes evidence, has witnesses.
Yes. So you present your case like you would in court. Essentially, you're going to, make your arguments, if you have witnesses that are going to speak. And that, again, kind of differs from mediation, where I think, it's really tends to just be between the parties sort of discussing, kind of what, kind of trying to get to like the underlying root, whereas arbitration is still it is still a more formal process.
But the cool thing about arbitration is if the parties are playing nice together in the sandbox, they can deviate from the rules, our rules. We have set rules, so do other institutions. Can't do that in court. You go to court, you're stuck with the rules no matter what. Mm-hmm. Even if the parties are playing nice together, In arbitration, there's so much flexibility, and that's what I love about arbitration.
Yeah, it becomes the party's process in a way, because and I'll touch up on this in the next question about contracts. But that's what's great about it, is you're in control. And again, Elizabeth mentioned it was less formal, but if two parties agree and say, hey, we want this done in 6 months, we want this judge to hear it, and we want the award by July. If they're in agreement to it, we'll do it, despite, our rules saying 30 days or whatever it may be. So it really is like you're in control of your own case, which is really nice, because a lot of times in litigation court, you really don't know what's going on. There's motions, you have delays, tactics, things like that. So.
And you pick your decision maker, like you
Right.
The fact that you pick the person that's going to hear your case is so huge. I used to go to court as a lawyer, and the judges are on rotation. And you're stuck with the judge that you don't like necessarily, or he doesn't like you, she doesn't like you, whatever. In arbitration, you actually can look at the backgrounds of these arbitrators and decide who's going to hear your case. Huge, especially if you're doing a construction case or any type of a complicated case where judges are great, they're really intelligent people, but they may not know anything about construction or architecture or whatever. So you have someone that's an industry expert, which is so key.
And you have the ability to do that. We have a panel of a lot of niche experience. So if you have one of those cases I just had one about farming. I had to find an arbitrator up in upstate New York who had experience in farmland. And we have the ability to kind of narrow that down and find what that experience that you're required, which, like Jeff said, judges don't really do that. They're rotated in and out. They're getting the file right in front of them and they're looking at it, and that's it, So that's really beneficial about it. You're in more control.
Yep. And AAA can tap into arbitrators from all over the country, right?
Mm-hmm.
Yeah.
Yeah. We have 6,000 arbitrators on our panel with all different industry experiences, which is terrific. And you can't do that in the courthouse. You're going to have a judge that's probably a brilliant judge, understands the law, but does not understand your specific area of dispute, and you have to educate your judge then. And that takes time and costs money.
And sometimes it doesn't work. Sometimes they don't want to hear it. So.
Also, doesn't AAA place an emphasis on presenting possible panelists who will be the arbitrator, who are from diverse backgrounds?
Absolutely.
Mm-hmm. Yeah.
Diversity is a huge thing at our company. Our lists that go out for arbitrators has to be a minimum of 30% diverse. Usually it's around 35 to 40%. So all of our lists that go out have to be that, and we meet that. And we're a not-for-profit, and we make sure that we're meeting that. We care about that a lot. If you look us up, you'll see that that's something that's an important thing at AAA.
Thanks. Are you having trouble hearing? Should we speak louder? Yeah.
Yes.
Thanks. It's hard to know what the acoustics are like. No. Also, there's no microphone, so anyway, we'll speak up.
Yeah.
So, Jen, tell us when you might, other than going out and choosing arbitration as your method of dispute resolution, when you might come across arbitration when you're in the midst of a legal dispute.
So this is the number. Well, Elizabeth will know this as she trains her case managers, but the biggest thing is look at the contract. Every single new case, look at the contract. What does the contract say? Now, the difference between court is you can go down to court and file a complaint. With arbitration, you need us in your contract in order to use our forum. So that's the main difference between
Or
court.
you can agree, right?
Or you can agree,
So
correct.
yeah, and that's always, I feel like going back to like the contract thing, which is always kind of always been fascinating to me, is you can really contract around anything, right? So unless it's actually illegal, which there really are very few things, like you can agree to, I don't know, have an arbitrator who specializes in ham sandwiches, right? Like it could be whatever you want, which is definitely very different from court.
So when you have a dispute that arises from a contractual relationship, you said that it would be named in the contract. So for example, there will be a section in the contract that says if there is conflict between the parties resulting from anything under this contract, the work, the relationship, then it will be resolved through binding arbitration.
And unfortunately, once that's in the contract, fortunately, because it's arbitration, but a lot of people don't know arbitration until they go to sue someone, especially in the consumer division. A lot of credit card companies, telecommunications, a lot of them, I mean, we all have cell phones, we all have credit cards. We don't pick the contract, we sign it, and we use our credit card. A lot of people are noticing arbitration because when they want to file a dispute, they go to their courthouse and the courthouse says, oh, no, we can't, we don't have jurisdiction. AAA is named here. So that's how kind of they find us, because obviously nobody wants to get sued.
But to your point, we're drafted into contracts all the time.
Yeah.
And for everyone in this room has a cell phone. And so probably there's an arbitration provision in there. Also, when you go to get a job, there's a lot of employment arbitration clauses. Just remember, that's where we get a bad name. Arbitration gets a bad name in those two areas, consumer and employment. But we're not the bad guys. We don't draft ourselves into contracts.
Right.
People draft us into contracts. And what we do since the 90s, we level the playing field. The consumer, us all in this room that have phones, we don't pay for the process. The process is going to be paid by the company. Okay, the arbitrator will be paid by the company. Same with employment. So just realize that a lot of people give us a bad name for arbitration because of the contract of adhesion, which means you're forced into arbitration, but we're not forcing you in. People are drafting us in. We're just trying to make the process fair. And that's the thing that drives me crazy, that people give us still a bad name about that.
Sure. And so when you're talking about, the different types of contracts, so you say, when you have with your cell phone provider,
Yep.
all the fine print when you're on the internet and you get a pop-up box of terms and conditions that you don't want to read and you have to just click something, there could be mandatory arbitration language within those terms and conditions.
Right.
So it's everywhere.
Right.
But it's not us. It's not us drafting it.
Right.
And then we try to say to the consumer, they have to register with the AAA, ICDR, the other institutions to register with us. And we'll look at the contract and make sure that it's even playing field, that the consumer has a chance to select the arbitrator, discovery, and all that kind of stuff, and not pay for it. So but it drives us crazy because we still hear every day that arbitration is bad because of those two areas.
Yeah, and not getting your day in court. Everybody wants their day in court, which, they say that, but you still get your day in court with arbitration. As Elizabeth said, we have virtual hearings and we have all that. You're still getting your day. If anything, you're more in charge of it. You're more in charge of how the process is going to go. So I still think you still have the opportunity to speak in front of an arbitrator just like you would a judge in a courthouse.
And I think we've started talking more about the consumer setting where you might come across contract terms in your consumer contracts in your daily life when you would find arbitration. A lot of company to company relationships, especially, and I would imagine you would find, like, if you're involved in construction with a non-tribal subcontractor or general contractor, you may choose to write into that contract arbitration as your chosen method of dispute resolution, which requires a waiver of the right to a jury trial and I believe some limited waiver of sovereign immunity because you are choosing arbitration rather than traditional tribal jurisdiction. Yes.
Good question. Right away, I was just thinking to myself, right? I challenged a lot of court cases on my own, just my own tribe.
Yeah.
And waiving the immunity is crazy.
Yeah.
We would never want to do that. That's number one. Number two is arbitration and challenging jurisdiction, and then having set precedent cases positive for a jurisdictional case for a tribe is very, very important. So arbitration is like completely reversal of what we would want to do in that case. We don't have enough set precedent jurisdictional cases that are being done, especially here in the Northeast region of Indian country. So arbitration sounds cute. It really does. It really sounds cute. But I don't think it works in a real way. Now, sure, say the tribe has this Aboriginal title, right, that has quasi power and then no power to it, because Aboriginal titles are basically treaties over here, the way that they were developed, especially if they were from courts that were competent jurisdiction under the King of England, which happened mainly in the 1600s. So we have a lot of our titles that were from 1600s. And so there's no real power in that. but there also is power in that. There's jurisdiction power in that. However, if the judge is incompetent to stand trial with a tribe that understands that, then sure, it may not work. But what I'm saying is, it can be used probably, like you said, stop and shop, build a stop and shop on tribal territory. Arbitration might be helpful, mediation might be helpful. However, I think there's a bigger picture for tribal nations when it comes to law, when it comes to court set precedent cases, especially in our region where we just don't have enough support around cases. Like people, like the honest truth is, when we find lawyers, two things happen. One, somebody else retains lawyers that we can't get them, so it's a conflict of interest by way of agreement. So you get one person who, you get 4 or 5 law firms that are like, oh, we actually represent the same party. Somehow, I don't know how you all's conscience work, but somehow I've seen that you guys represent, not you guys, but law firms end up representing 5 different law firms that specialize in tribal affairs, all represents this one party. And then so when I go and try to get a lawyer, I can't get one because they're you guys are retained. And then 2, what I noticed is that no one's competent enough to deal with jurisdictional law around here when it comes to Aboriginal title, which is, it's a treaty-based title over here, but because it's not familiar in Indian country, it's not familiar with Indian law, it's really hard. And so when we do actually get those type of cases and we do get a win, for us, it's more important not to waive sovereign immunity by law, but to actually have set precedent cases that are supportive to us so that other tribes or my sister tribes can use also as case of precedent.
And are you talking about cases that are decided in the tribal courts or
No.
federal Indian law
No.
decided in
Federal.
in the American courts? Okay, yeah.
They don't even, I mean, the courts around here are too incompetent to even understand subject matter jurisdiction to lateral a case to a tribal court. They don't even really know how that works. There's no clear language of relationships between state compact law and then going into tribal law. There's nothing really clear.
Yeah, so
Maybe you guys could, maybe arbitration could help in the way of you all being the navigator or the communicator to the state around them being able to transfer jurisdiction some kind of.
Well, the parties could agree, and I
it's
oh no, but
I learned a lot, actually.
No, that was actually
I love hearing that.
No, that was
seriously.
really great. But I think arbitration would probably only work, kind of in the context for the tribes in a really like business to business kind of commercial contract sense, right? Like so, like you were saying,
Non-business?
like so. Say for example, I'm just going to throw this out there. Like so, Foxwoods like signs a contract with a contractor to build something, right? And so. And this is totally like maybe not even a great example, but that might not be it. But, in that commercial contract context. But then I'm also thinking, and Jeff, I'm going to punt this one to you, because did we not back in the day actually have some tribal
We did.
arbitrators who
We-
specialized in tribal law?
We
And
did.
I don't really know.
We
the
had arbitrators that did specialize.
American Arbitration Institute.
Okay,
And I specialize in tribal.
there it is. Okay.
Yeah. Okay. Cool. Yeah.
Let me just interject here.
Yeah.
You're absolutely right. What the AAA, what mediation, what arbitration is about is alternative dispute resolution. So we're talking about disputes. What you're talking about is jurisdiction.
Sure. Yeah.
I worked here for Foxwoods a little bit, just retired from the Environmental Protection Agency, but have been practicing tribal law for a long time. So you are absolutely right in everything that you say. And this form, as AAA was trying to explain, was for dispute. So it's more, it's landowner. It's, I did a lot of employment opportunity, mediation. Arbitration is where you're applying the law. Mediation is where you're trying to find a win-win.
Yep.
So
And we're
it's
going to
focusing on that
get to that.
dispute where
Yeah.
you're focusing on law and jurisdiction, and that this is not the right forum to set those. But I think, I think land is very sensitive around whether it's dispute or jurisdiction.
Yeah.
Right. Yeah. 100%.
So just to your first comment, we would never suggest that tribes should waive sovereign immunity for cases that would normally go to the tribal courts. Not at all, or even in the federal courts. What we're suggesting is that there are circumstances where you're either going to find in your contract or you have an opportunity to arbitrate cases that would be in the American legal courts that would be to your benefit to have either because you find it in your contract, like in a consumer contract, or because you want to have a subject matter expert that knows federal Indian law that would take, it's up to the parties to present that tribal precedent, and the arbitrator would consider that as part of their award. So,
Unfortunately, a lot of our law around here doesn't fall under federal law.
yeah. Did you want to, go ahead, please.
You're a national company.
Yes, international.
International.
Yeah, we have 28 offices, one in Singapore. So
And you mentioned in traveling over 50 states plus beyond, correct?
Yep.
And what's the safest places to go and destinations, all that. Am I correct?
I'm sorry.
And all the safest destinations to go to. Map it off.
Oh, no. We were just talking, that's like we were talking about the locale of the case.
No,
Yeah.
I'm speaking for AAA,
Yes.
right?
Okay.
Am I correct? So is there any mention of any of the 570 plus federally recognized tribes in your information that you send out? Because we seem to be invisible to so many people out there.
Yeah, that's a good point.
And there's only recognition for the states.
Right.
That's really interesting.
So I would like to see the federally recognized tribes to be mentioned in your handouts, so that people know that we are not people of ancient times.
Well, no, that's why we're here today. That's why we're sponsoring this event, and we think this is important, and that's why we're a part of this. And, yes, do we mention it? Probably not right now. But do we have arbitrators that are on our panel that are experts in the area? Only a few. But with arbitration, you can always pick someone that's not even part of our panel.
No, that's not the same thing.
Okay.
I'm saying to recognize us, to see us as a people. We cannot be erased. And because you are international, when you list just the states, we are being erased.
But they don't list anybody.
Yep.
They just
They do,
list them.
I'm saying they list the states, they'll say Rhode Island, and where to go, and what to do, and where to be.
Well, that's where our offices are.
Yeah, that's just based where our offices are. It's physical locations. That's it.
I think you're saying, like, if you're going to say, hey, we practice in all 50 states, you would also want to mention we also, if it applies, practice with 536 federally recognized tribes. Is that what you're saying in the marketing materials?
570 plus.
Okay. Yeah.
And this is a lot of things we take away from these talks too, especially Jeff and I, when we talk in front of crowds, that we want to educate you, but we're also here to get educated as well. I looked up your website and things like that, but what's great about the AAA and arbitration is, we can take your feedback and we can take it and apply it and do what we can. Unlike the federal court system where they kind of just hear your feedback and it's like, whatever, these are the rules, who cares? But I do want to let that be known is I'm here to be educated as well. And we won't know what to do to better that unless, people like yourself tell us. So.
Well, I was just saying for the fact that I'm trying to remember here in Rhode Island.
Yep.
And I get in some kind of situation on a reservation, maybe in Florida.
Yep.
There's arbitration that I can use. There, I can work with the tribe, I can work outside of the tribe.
Well, and you can select that, right? So that, that is like when that could be written into a contract, the actual location. So you could actually put that specific language,
You set your standard in your contract.
in the contract language that where you're sort of saying if we have a dispute, we're going to go to arbitration. That's administered by the American Arbitration Association, and you can put in specifics, right? So, we would want to, have the locale set in Florida or, Oklahoma or Rhode Island, and that's where we would want the arbitrator selected from, or where we want to have the actual hearing. So you have a lot of control.
I'm just saying, AAA is huge. It's huge. They do a lot.
Yeah, we're
It is no, and and it's really interesting. I mean, I don't even think that has ever really occurred to us, right?
But that's why we're here today.
Yeah,
That's why we're
but
here.
that's a really
like Jen said, we're here to listen to what people are saying in the community and to get feedback. And we're always changing. We are. Yeah. No, absolutely. No, and that's why, again, that's why we're here. That's why we're a sponsor for a lot of organizations around the world. I mean, that we want to hear what you guys have to say. We always change our rules. We change things at AAA constantly.
yes, we're working on some rules right now. A couple of times. So yeah.
Other than hearing, you do take that information, bring it back, and
Absolutely.
consider it.
Oh, yes,
Oh,
of
Without a
course.
doubt.
A lot of the workings we have going on right now, and what I'm working on, came from public speaking, learning about things, and a lot of the times when we talk to attorneys, they'll tell us about certain cases that they've had with us and the inconsistencies, and we learn that now. And part of our jobs is to do what we can to make it better. So your feedback was really helpful.
No, it's meant to be a flexible process.
Yeah.
Go ahead.
I think that take off from what Bella was getting at. Are there examples, and Valerie spoke of her experience, are there examples that arbitration process, working with tribes, or tribal companies, whatever, that may be helpful. Tribes, part of the process of trying to work out issues, this builds itself and sounds good, but tribes, tribal members, tribal companies, whatever, you go in apprehensive in any process. You're already thinking you're going to be disadvantaged because of, let's face it, history hasn't been kind. And I think Jack did it, he spoke of,
Jeff.
he spoke of diversity on some of the panels that they don't include Native Americans, then we're already questioning it.
You're right.
Going in as a tribal company or tribal nation or whatever. And, the sovereign relinquishing it or whatever that was, earlier spoke of. That's would be an unacceptable thing on the part of the tribe, tribal nation, or even a tribal member, because that's part of what and who you are. You've already had taken from your people that you go in with some kind of question.
Mhm.
Is this process going to be fair regardless, certainly in the courts?
Right.
So maybe this allows itself to be something different from the courts because we know that's not usually a good avenue. But other examples of this is getting back to my question, are examples out there that you guys can check. If a tribal member or tribal nation, tribal company, or whatever, is considering signing into the arbitration process or an issue that might come up with non-tribal company or perhaps even bigger on the state or town or whatever the case may be that surrounds the reservation.
Sure.
Are there examples that you've all worked with?
Like actual arbitration.
It's a private process, but there are examples. We've handled cases over the years. But the beauty of the whole process is that you can select someone that is part of the tribal nation, just to hear the case.
Even if they're not on our panel.
Even if they're not on our panel.
Like you could select somebody that you wanted to hear it, and they don't have to be a lawyer, right? They don't.
Yeah.
You could really select anyone you want.
And
Quite frankly, if the parties agree.
Not so much with the tribal nation, but we see it with other organizations where they select someone that's not on our panel, but it's someone that they feel comfortable with, both sides. Okay. I had a case recently with Hasidic Jews that they wanted someone that actually understood the religion, and they selected someone that was not on our panel. So you can do that. I mean, we see that all the time. So.
And I hear you asking for, has this happened? Do you have some case studies? I can't say that we brought any case studies today, but we could certainly look into that and follow up with that information. I would think that the folks, the Pequots building Foxwoods, had to have come across these provisions in their construction contracts.
We've had cases, without a doubt, but
frequently
again, it's a private process, but we do have cases. We've done.
I know the tribe is considering this for tribal businesses. you know, trying to take advantage of an opportunity that keeps the issue out of court. And, yeah, we've worked with this issue, we've worked with this going on. Just a point, I guess.
And
Yeah,
you can
thank
also you can also kind of like, you know, weave in and out too. There's some conversation that's happening right now, I think, in the industry, right, about sort of this arbitration mediation combo, right? We kind of weave in and out. And I think that's kind of the beauty of arbitration. And you can do it in court too, but like at any point, you can essentially pull it out of arbitration and say, hey, you know what, let's try to mediate instead so that we can, without, you know, sort of, you know, this neutral that's going to make the decision. And you can also kind of pick and choose a little bit. So you could, you know, maybe, you know, narrow your issues, right? You could kind of mediate some issues and come to an agreement, and then like whatever's left that needs to be decided, then kind of take it to arbitration for a decision maker. So there's a lot more flexibility in the process.
So, yep, go ahead.
I also think it's a little difficult with arbitration sometimes, just because the ambiguity around the sovereign power of the tribal nation is always at question. And it's like, what are you going to do? You know, as a tribe, that's what, even like with a town manager, and you have land rights that are in the town, whether they're Aboriginal use of rights or just federal land rights. The town, I often have experienced that they're like, what are you going to do about it? And so they don't even feel like there's an obligation.
You don't feel the pressure.
To have an answer.
Yeah.
An email or, you know. But to that, again, I guess if it was a letter from an arbitrator, maybe, you feel more pressure.
I think,
talking about
yeah. I think mediation is probably a better setting, and we're going to talk about mediation in a second for that kind of dispute.
Mhm.
Let's talk about mediation, and then we could maybe circle back to that comment. But before we go down that road, Jeff, did you want to just tell
I'll
us?
be real brief.
Yeah. Jeff just wanted to share some resources that AAA offers.
Yeah, we're here. We're here as a resource too, and please feel free to call any of us, contact us if you have a dispute or whatever, or if you're thinking about negotiation, mediation, arbitration, whatever. But we have a foundation, AAA ICDR Foundation, and we offer training programs for diverse individuals in this country. Anywhere in the country they can go, or anywhere in the world, up to $2,000, and we're a not-for-profit. AAA ICDR Foundation, look it up, a one-page form to go to programs on negotiation, on mediation, to learn a little bit more about the process. And again, we're giving away money. So please look into that, and we're a resource. Please use us. We're not-for-profit. We're here to help out people. Even if you don't file, we don't care if you file a case with us. We're here to help out people that are negotiating issues or having disputes and things like that. Use us as a resource. Look up the AAA ICDR Foundation. It's not an ad, but
we have a lot of money
We're
that
giving-
we're trying to give away.
we're
So
giving away
definitely
money.
look.
But please, we don't advertise it a lot because we don't have money to advertise. But it's there. Look it up, please. So,
Thank you.
yes.
So I have a question.
Yeah.
You say you can choose your arbitration.
Yep.
But educate us on the process of that, right? Because it's a two-way street,
Sure.
right? You know, it's not just you choosing, it's
The other side.
agree of parties, so
That's right.
to understand that. And then, so in your process of choosing, how do you go, help us understand how you go about choosing the right person to arbitrate? Because again, you have opposition, and that opposition has to agree, right?
Sure.
So what's your take on that?
Well, it's a flexible process, like we mentioned at the beginning. But if the parties can agree, we hope they can agree and pick someone. A lot of times they don't. You're right. So then what we do is we generate a list of arbitrators up to, sometimes up to 20 names, 15, 10 names, and we'll give the parties that. They do a strike and rank listing system. Or a lot of times in a lot of major disputes, we see them agree on someone. But yeah, I know you laughed at that, but that does happen sometimes.
And if in a larger case also, you might have 3 arbitrators, right? So typically how that looks is each side picks one.
Yeah.
And then the third arbitrator is sort of like the.
Sure, we're talking about
Contractual.
situations anyway. But what I'm getting at more specifically, like, is the character of the person. So when when the team gets together, right, presumably we're talking about company against company.
Yep.
Right? So when the team gets together and say, okay, let's look up let's look up AAA, and let's look up this other company and figure out who works best for us.
Sure.
Right? And you said you have, a large number.
Like 6,000 arbitrators.
Whatever it is, right? So it's a large number of arbitrators. It's not a matter of just going in there and picking up a name, right? It's a matter of going in there and picking up the character of that
Right.
person. You
Absolutely.
understand what I'm saying?
Yes.
And so what I'm really asking is what resources for us are out there that help us to do that? Because
Right.
it's not just saying we found a firm, they got good people, this person studies Indigenous law, so on and so forth.
Yep.
Is there information on winning law scenarios? Is there information on, profile on you?
Well, there's profiles on the arbitrators. We do provide a resume, a long resume of each individual, how much they cost, all that kind of stuff. And we even have little videos of the individual, a 2-minute video of the arbitrator or the mediator that you can see you can kind of get a little feel for their character. So we do offer that kind of stuff, but you can also do your homework.
I'm sorry. Before
Can you interview?
Well,
You can-
before,
Thank
that's
you.
what I was going to mention. And also as a case manager, just to give an example, I handle the large complex cases. So all my cases are over like $10 million. But part of my job, before the case even gets started, before we appoint a neutral, is I sit on the phone with both parties. And that's really where I get the information on what party wants what on the neutral. So it's not like I'm going into this list blindly, taking the claim and saying, okay, breach of contract, let's see what we got for breach of contract. That administrative conference call is where I, as the case administrator, hear each side, where they're at. And you guys will say, for instance, I want a tribal member who specifies in financial services, or, that's the time where you let me know. And then when you get that list, that's when the resumes come in. That's when the resumes are behind. You can watch the video, get their demeanor. And so that's how we learn. That's the resource. That's the resource.
But
there's-
Laura mentioned the interview.
Yes, the interviewing, yeah.
You can, if you want, no additional cost, you can interview the panels. Let's say you guys both sides agree to 5 arbitrators. Okay, and then you can get on a Zoom call or in person or via email and interview those arbitrators, which is really
So
cool.
that's what I'm just saying, is just for everyone who's here, and I just want to make sure that we all understand that we have a responsibility to request that, because we're not exactly advertising that.
We're not.
You know, this is a real quick one.
You're
I want to
absolutely
make sure that we're all, with a clear understanding that we have a responsibility to pursue certain things, especially contractual, even down to having an arbitrator. I mean, and in order to do that, that needs to be written in, right? But that's not given.
Yep.
I thank you for that, because it's leading back to when I said, well, you just said we contract the tribal members or whatever. How? You don't even have a relationship with them. You have no relationship with them. You don't have.
No, we don't contract.
No, we don't.
We're talking about when
We don't.
this happens, whether you're a consumer or when tribal and non-tribal companies are working together and they develop their own contracts, they can choose arbitration. We're presenting this process as you come across it, or if you get involved in a dispute and you decide to contract for
You said you
arbitration.
have a list of arbitrators.
Yes.
Yes.
We give a list, we create the list and give to the parties.
Right, and you have, there's already people with resumes ready and available, right?
Yep.
Yes.
That's correct.
But do you have Native Americans ready and available?
We do.
Yeah, and part of the process too is our case managers, there's boxes where you can kind of put your locale, see what you want, and there is, I think it's tribal member, like there's a checkbox. So when you hit the search, it'll grab that information from their resumes and bring it up to the case manager, and it's their job to go through it.
The tribes to establish this list of tribal.
No, we're not working with
We're the
tribes.
neutral.
We're the neutral.
No, so a tribal member might want to be on our panel.
I'm asking a question. When you start, I'm asking a question, now, please let me finish. So my thing is that tribes determine who the tribal members are, not an individual.
Okay.
Yeah. No. So we actually rely on.
You can choose, you don't have to choose from the list.
Well, so
We want to just make sure that we have time to talk about
Yeah.
mediation. We have 15 minutes left.
Real quick,
I was just gonna,
Okay, sure. No, we want this to be Q&A.
no, absolutely.
There's not a lot of time. Yeah, go ahead. Of course, yeah.
Legal jargon stuff, but she knows what she is saying, so I'm gonna just speak for her really quick. What she did say was something I was interested in, and I didn't even think about it. Most of the things that deal with tribal anything, they're not really arbitratable.
No, they're not. When it comes to family, rights, land, stuff like that, you have to respect.
Yeah, no, you wouldn't,
Without a doubt.
no, absolutely. Yeah, we're not suggesting
We're not
that you.
pushing any of that.
What we can arbitrate when it comes to our culture and what we do. Because I am in the court system and there's a lot of stuff that cannot go through arbitration.
Right.
Yeah, 100%.
And we're not selling
100%.
arbitration
Yeah.
in those areas.
So-
100% right.
You can read that wrong or read it
Yeah.
wrong. There's only certain things that can be touched and certain things that have to go through.
But that's a nice segue into mediation.
Yeah, exactly.
Mediation, mediation would work for those things, and I think those are powerhouse that all tribes are.
So let's,
That can't be through mediation.
okay, so not necessarily through arbitration, but if you're in court and you know that the case has to get resolved in court, you can try mediation while the court case is pending. And let's talk about that for a few minutes. So mediation is I'm going to just explain the differences. So mediation is very different in that the parties agree to try mediation, which is really a negotiation, and it's in a neutral setting that the parties choose. They choose a neutral mediator who that they have trust and confidence in. And that honestly, like the data show that trust and confidence in the mediator is the number one reason that parties are able to resolve their disputes with mediation. And what happens is and this often happens when a case is pending in court and you have a looming deadline of a trial or a hearing or something. So I'm thinking back to the discussion from yesterday where the folks from Hawaii shared, that they wanted to file a quiet title action and get the court to rule on these lands that were adversely possessed from them, right? Well, you're probably not going to get those companies to come to the table unless you've already filed a court case and you have a hearing or a trial date pending. And then those companies are going to have the pressure of, okay, a judge might decide this, so let's see if we can try mediation first to mediate a dispute before it gets heard by the court. And if you're able to mediate and come to agreement, then you put it into a mediated settlement agreement. The terms are completely confidential, but you do present to the court that the solution has been reached, and then the case can be dismissed, or parts that need to go into the court record can go into the court record by party agreement. And that's a circumstance it's especially good when there's many parties, when you have a lot of different interests involved. The mediator will work really hard in advance of the mediation session to talk to each party individually. You can't do that in arbitration because the arbitrator has to stay neutral like a judge. But a mediator can talk to each party individually, understand their interests, then bring everybody together in a session where they share their interests with each other. There's a huge emotional piece. Every mediation has an emotional piece, and then the transactional piece, which is, the nuts and bolts of how are we going to resolve this. But the beauty of mediation is that there's time and there's leeway for people to share their stories and for people to hear each other in a confidential way that you wouldn't otherwise necessarily have in a court case. And when it becomes necessary, the mediator might separate the parties into what's called caucus. So you're in your separate rooms, and the mediator serves as a neutral messenger to share information, share settlement offers, and it kind of neutralizes the situation so that people can listen and hear in a more open way. There's a lot to say about mediation, but I'm trying to do it very succinctly so that we have
My
time
biggest
for
takeaway
everything.
is just the salvaging of the relationship. That's one thing I see in a lot of mediations, especially when it's a business divorce. You can still have the ability, if you mediate, it's such a different dynamic than arbitration that a lot of people are able to salvage that business relationship
That's right.
together, or salvage that friendship, or whatever it may be. That's my biggest takeaway coming from sitting in mediations. I see it. They come in, you can see it on their face at the beginning of the day. Everybody's stressed out. By the afternoon, we have a settlement and they're walking out together to get lunch. So that's the biggest takeaway for me for mediation is the salvaging of the relationship.
And you can be very creative in your solutions. The mediated outcome could be anything that the parties agree to. It's especially helpful in, as you're saying, Jen, like situations like family law, child custody. I'm actually, again, thinking about that land dispute. If you had a bunch of parties who wanted to use the same parcel of land and they could come to agreement on how and when that might happen, that's something that would come out through mediation. That's a judge is going to either rule that you have title or that you don't have title, or you have a license to use that land or you don't have a license to use that land. So this is a good option. And if you fail, then you just go back to the process that you were in. You go back to court or you go back to arbitration, and then you end up getting your case decided. So I don't know, Jen, do you want to pipe in with anything to add on that?
Sure. I think that, as you had mentioned earlier, mediation is most closely aligned with tribal peacemaking in such that it's based on relationships and maintaining those relationships and strengthening them, repairing the harm, and the outcome to the community is considered in the process.
Yeah. Thanks. Yeah. So we have Tricia Driscoll here from the Center for Mediation, and she's going to explain a little bit about what the center does. I'll just let you take her.
Did you have a question before?
Yeah.
Oh, it's not now. There's a lot of pressure. What if it's not? Oh my gosh. All right. Well, again, I just want to echo. Yeah, I want to echo what everyone said, and our gratitude for you all being here today. I mean, it's clear that we have a lot to learn, and I think what I hope. So, I work at a community mediation center, which is a little bit different. As Jennifer said, our model is the peacemaking process. It's not as good. I mean, to be honest with you, in mediation, we're empowering the people in conflict to come to a solution that works for them, that makes sense for them. It's a path that makes sense. Where we haven't gotten to is the larger community, right? Those ripples. So we understand the limitations of that. I think within our community mediation center and every other community mediation center, we're not doing the same type of disputes that AAA or that we're not doing arbitration, we're not doing business mediation. We're doing mediation between people in conflict. That's families, coworkers, neighbors. Those are the disputes that are really kind of tearing at the heart of people's lives. If you've ever had a conflict with someone you really care about, it takes a lot out of you. It takes a lot out of them. And so those are the situations where our community mediation center tends to live. We tend to do work around trying to facilitate conversations in communities where there are two sides to an issue, which there always are. Usually there's a third side and a fourth side and a 10th side. Our role is not to be an arbitrator. Our role is not to be a judge. Sometimes our mediators refer to themselves as sort of the potted plant in the corner of the room. Our role is to hold a safe space, is to give individuals an opportunity to share their perspective. We're going to remind people that you have a perspective and so does everyone else. So not only is your responsibility to share your perspective, but it's to listen. I know this sounds very like, oh, that would be so nice if everyone sat around and listened. Like, I get that. It also, right? Many of you are likely mediators in your world. Whether you took a training or not, whether, whatever. You are probably someone who other people naturally come to, right? If you are that person, then you are at your core, you're a peacemaker, you're a mediator. And I think what we hope to do is to continue to empower more people to be in that role, either through our training, through education, through just being out there and listening. That's what we're trying to do. We serve, we're from Rhode Island, so we serve Rhode Island. There are community mediation centers all over the country that are doing very similar work to us. But I would simply offer that if you have situations where you have conflicts with people, you should you might want to reach out to a community mediation center. That doesn't mean they're going to be, they're not going to solve your problem. I can guarantee you that. What they do is they offer you an opportunity and a safe place to have that conversation where you can find the path. Because as Jennifer said, mediation is all about preserving relationships, right? It's all about preserving relationships with your family, with your coworkers, with your neighbors. That's what mediation does. And that's where it's most effective. So, okay, how'd I do? Was that all right? All right. 'Cause I'm nervous. Now I'm super nervous.
For me, mediation is basically stepping representation, right? Because they're being represented. But when you're in a position of mediation, now you have this mediator that steps in. So it's a step in representation that goes between the parties, correct?
Yeah.
Right?
In some so in some cases, right?
In most cases, right?
So for us as a community mediation center, actually not.
Okay.
So, but for sort of formal mediation centers, yes. So what I'm hearing you say, and correct me if I'm wrong, because I'm wrong. I'm wrong about half the time. So in a mediation, the most important voice, the most important perspective is not the mediator. It's the people in conflict, and so the mediator is never going to speak for those people. I may, as a mediator, I may try to highlight some things, but I am never going to interpret. I am simply going to reflect back what you've said to make sure that everyone else hears it. Does that make sense?
Yes.
Are we saying the same thing and I missed it? Okay, all right. No, that's okay.
No, but that's good. Thank you for that.
Sure.
I think what I'm trying to get at is that for us, it's important to know that for me, the way I envision mediation is it's an opportunity for us to feel more comfortable and to be in a position to be able to truly ask for what you want, truly go after what you want in an atmosphere where you're just given a little bit more comfortability to speak, a little bit more comfortability to be transparent in your expectations of the outcome.
Right.
Sometimes when we're sitting amongst the lawyers,
Right.
what I mean?
Yeah, that's fair.
Pressure. Okay, did I really ask for what I want? Am I settling too soon? Or, am I in a position, do I truly even understand what they're saying to me right now? So
Yeah.
you're sitting in a room with people who are pressuring you to make a decision. Let's just be real about that.
Yeah, and that's really fair. And I think what's so important about what you said, and Laura alluded to this earlier, a mediation session is confidential. So there's nothing on the record. No one's going to come back. And in fact, in Rhode Island, this is not necessarily the case in every state, but our mediators are bound by a state statute that we cannot reveal the contents of that. So let's say you're in a mediation and I'm your mediator, and someone decides to subpoena me. I can't speak about that. So there is that reassurance, I guess, or the comfortability that you speak of in a mediation session that you can say what you want to say. And there's no question that mediation sessions get heated sometimes because people are very passionate about their sides, and that's okay. I'll take a raised voice or two. We're not going to take fisticuffs, but that's okay because we want, again, the goal of a mediation session is your goal. I have no stake in this. Yeah.
Yeah, they're really focusing on like it's really that underlying, whatever the underlying interests kind of got you to the place where it is. And they can kind of help redirect you if you kind of go off, start to, kind of maybe flow. But it's also good to go off in different areas in mediation too. You want to kind of go off so you can kind of figure it out and come back. And I think it's a much less, I think everybody, and even those of us who work in sort of the legal field, I think court is intimidating, arbitration is intimidating, just the actual physicality of being in a court, right? Like going to court, even to go to mediation, right? So there's also this idea of sort of out of court mediations, right? Where you can go someplace that's comfortable for you, kind of takes that intimidation factor out a little bit because it's hard.
Yeah. Did you have a question, sir?
No, I was just going to say, so I can mediate in Massachusetts.
Yes.
Massachusetts are taking that a lot of so small claims courts.
Yep.
Some of your process is mandatory.
That's right. Love Massachusetts.
Same in
I think part of
Yeah.
that part of mediation is safe space. That's my question.
Yeah.
So, the best part of mediation is the parties. We literally were just there to facilitate a conversation.
That's right.
I was in mediation, and the more senior mediator said, "Hey, we're not going to look at evidence.
Right.
Make sure
Yeah.
we decide this evidence.
Mhm.
We want to figure not to be the judge."
That's right.
So,
Yep.
And I think one of the parts that we like about mediation, particularly, the parties really come up with the agreement and it's over a car Peter, and at the end of the agreement, the plaintiff just wanted the mechanic to sign
Right.
the sheet saying, all right, I verified that that's
Yep.
what they should happen. They both give me he gave me the money.
Yep.
And they all
It's never about the money.
Exactly. First.
Yeah.
So,
Yeah.
I think the part of that really stays thing. So I want to ask you,
Sure.
what CIPR experience, what have you done to better create?
Yeah, I think first and foremost, as Elizabeth just talked about this, so we do mediations in the courthouse, but also outside the courthouse. And obviously outside the courthouse is much better. The court is just makes people feel hard. So we, our space, this is going to sound silly, but, we have a space, we face each other. We have water, we have tissues, we have things there that hopefully make people feel comfortable.
Food.
And sometimes we have food. Yeah. All of our mediators, that's their number one goal, because and someone said this earlier, it's all about trust, right? So you just met me, and I've got to figure out a way to let you know that I'm a trustworthy individual, and I don't have much time to do that, right? And so it's all about listening. I'm making sure that I hear what you say, and you know that. It's making sure that I acknowledge when I made a mistake, that I can come back and apologize and move through that if I need to. It's all of those skills those are the most important skills of a mediator, because it's about trust. If you don't trust that space, that it's going to be safe and that they're going to hold that for you, then nothing else matters.
I want to add, so I do the same thing in Rhode Island in the courts. So the Center for Mediation has a district court program very similar. And so we are limited to being in the courthouse in a conference room. But if any party says to me, I'm not comfortable sitting next to that person, I want to talk to you separately, I immediately break into groups and put people in separate spaces. And it's amazing. You can see the demeanor where people just start to relax, and then they talk more freely. And then you're able to make progress. But I'm always and our mediators always thinking about that. Is somebody uncomfortable here? Does there appear to be a big difference in power or bargaining power? You need to be aware of that and make some kind of accommodations, whether it's separating the parties, or if one party has a lawyer and the other doesn't. We might ask the lawyer to step out of the room so there's more of an even playing field discussion. So, yeah, we think about that a lot.
Yeah, sure. Thanks for your patience.
Sorry.
No.
So I'm trying to ask this question in layman terms, a little bit without knowledge myself, but trying to learn the knowledge and to just be often for my colleagues, the questions that he asked.
Sure.
Earlier.
Yeah.
You've explained, and some of us already knew, the process of mediation and arbitration. And now for me, because I know you don't have a lot of time, but in a summary, what happens when there is no resolution? What happens when there is no answer in the mediation? What happens when arbitration is not even can touch the topic of, because you're talking about, you're mediating and you're arbitrating something that we're not getting, something that we want or we need. And when you're not getting what you want and what you need, and when you are the representation, and I'll say AAA is representation, where do we go when that
Where's the next step?
representation is exited?
Yeah.
And when there's no answer, and even mediation, and I've been through the process of mediation in several cases with youth, adults, business, and there's no resolution, and like you said, you go to the courts. So the main process with this, in the, sorry, I lost my train of thought.
It's okay.
In the process of what say it right, the Indigenous process, where the case is not even recognized in the court. What you said, you want it to be recognized in mediation. Where do you go when it's never going to go to court because it can't even be recognized? That the court's not recognizing the case.
That's a good point.
That is a very tricky question.
Yeah, I mean,
I don't have an
Excellent
answer for that.
So if I may, I take it up to my colleagues, and that's evident. I can't eloquate the question as much as they try to eloquate the question, but I'm trying to say it in layman's terms. What happens now?
Right. What's the next step? Yeah.
Because you already gave the step, and a lot of us are already educated in mediation.
Yeah.
And arbitration, and you gave the steps, and like you said, it's all fluff, hey, can we get in the room and be my eye? And I heard you and you heard me, but at the end of the day, when you're talking federal law, federal case law, state law, and issues that are not even recognized, what happens? That's the answer that we're looking for.
yeah.
What happens?
I mean, I can't sit here and pretend that I can give you legal standing to pursue something that you wouldn't be able to pursue in court. I think what we're trying to say is if you have parties who recognize that it's to their benefit to work with you to reach a solution, because you either do have something pending in court or you have an untenable situation. You're all living on the same land and it's impossible to live together because there's so much conflict. Then you have these avenues, and in that case, it would probably be more mediation than arbitration to try to resolve that conflict. I can't say to you, I'm going to help you find a method to find a legal course for something that wouldn't otherwise be heard in court. It wouldn't be fair for me to stand up here and say that. But I am saying that if you get to a point of conflict where you can help parties recognize that it's better to move through that conflict than to ignore it or live with it, we're trying to present some alternatives to just suing in court. I don't know. Does anybody have other
No,
thoughts?
I agree with everything you said. But I mean, if you go to mediation, obviously, if it doesn't work out, it's what can you do? But if arbitration, the jurisdiction is a big issue. I mean, we really can't answer that, but we hope that people will look to us and other organizations to resolve the disputes. But you're right. If the mediation fails, what can you do? I mean, it failed. I mean, it's unfortunate, but we try to help out as much as we can.
Well, no, and I think part of your question really is to, like, even if you come to some sort of determination, right? Like if there comes to an arbitration award or you have a mediation settlement, but it's not recognized in court. And I think that's this big question. And I think to Laura's point, like we can't really, we'd love to be able to say, well, we can make it stick, right? But that's not, but we can't, right? So it is unfortunately at the end of it, right? Because even an award in an arbitration or a settlement agreement and mediation does end up getting filed in court, as a formal. So yeah, I wish I had a different answer.
So an arbitration ends in an award that is, you can take that into court and the court will recognize that, just as if a judge had ruled. So if you come to an award in arbitration, it has that legal effect. You just take that additional step of going into the courthouse and having the court recognize it. With mediation, if you do come to an agreement and it's a settlement agreement, it's a binding contract. And you could take that to court and say, that party agreed. They signed this. We mediated and we agreed to this. And the court can force them to do that. So then you do have legal recourse. I thought I heard you saying, like, if you fail, what do we do?
Yeah. You did say that. Yeah.
And you just said something different. You said if you win an arbitration, you can take arbitration
Award
to the court.
That's right.
And there is a winner and a loser, right, in arbitration, typically, right?
Okay, and so my question to that is, you take the award in arbitration to the court.
Yes.
And what if the court doesn't recognize that arbitration?
No, they have to. There's a federal arbitration act that requires the courts to recognize an arbitration award.
Okay, there's an answer.
Hey, we got an answer.
You know what I mean?
Yeah, no, that's
I
right.
couldn't say it.
No, you said it.
Yeah.
You said it very well.
I'm sorry, I didn't hear that before.
Yeah, I had it in my head.
You got it out.
No, and I kind of misheard it too. I was sort of thinking you were saying, like, if there was sort of a legality issue, like how could that be enforced? So I definitely misinterpreted what you were saying.
Jurisdiction.
Yeah, that's kind of what I was thinking.
And I was saying that the mediation, if you don't come to an agreement, once we can start in court, start like say small claims, small claims. if you don't come to agreement,
It goes to court.
actually
Yeah.
argue your point
Right.
in the law. So.
Yeah, absolutely.
The fact there is a federal law that will recognize the award of arbitration.
That's right, and state laws that reflect the Federal Arbitration Act.
Yeah, Native people have been involved in this for a long time. Treaties are part of that negotiation
Sure.
process. And we've seen what happened with treaties.
Yeah.
And I haven't heard any of you really talk about the power imbalance. When you're talking about commercial agreements, there's usually a venue clause in there that says that it's going to be in a state court or federal court, not in a tribal court. Most commercial entities, non-native, hate tribal courts, and they say out of any way that they can. I have a case where there's a venue requirement for tribal court. And with the bank foreclosure, rather than propose on it and lose the tribal court, they said that we refuse to pursue the contract. But, and you also have a choice of law provision too. In most commercial agreements, it's issued by state law. You don't apply tribal law. You don't apply the customs and traditions of the tribe in deciding a contract dispute, for example. And you're bound by the contract itself. The lease of provisions, and most of them are boilerplates. You don't have a choice when you engage, particularly in consumer situations. You don't have a choice in saying, I want tribal, I want my customers, I want at least to be recognized and respected. You don't have that. Now, I see your organization as having a potential here of actually pushing to have that develop, have that grow, and have that concept for tribal courts where outside entities are not afraid of going into tribal court. For a Native person to go into a state court or federal court is that experience is the same experience that a non-Native entity is trying to grow going into a tribal and have a customer resolution process. And while it's a way that you resolve problems too, the dispute resolutions, you do not apply to Native customs, Native traditions on how to resolve those things. Yeah, which is another area. So it's a very well-established big organization that has, as well as totally reliant upon the Western legal system and the Western ways of contract itself. Even though you're saying you're doing arbitration or mediation, you should have a contract act. And you should have laws, Western laws that have been developed. You're not following necessarily tribal laws and customs. So it's a long-winded question, but I just wondering if some of you could talk about this. It's a power imbalance not only between the consumers and the provider, but it's a double whammy because you get the Native consumer traditionally victimized, and they're also victimized because most of the communities have been put in poverty as a result of voting nomination for 2 years. So how you have an opportunity here as an organization as mediators, right? You can't ignore the law, you can't ignore the contract themselves, but you can work as an institution to try to address those problems. And so that the non-Native entities are actually more open to actually consider some of the Native approaches to problems.
I mean, we have a pretty big focus, and especially now we have a new CEO who came in about 1.5 years ago, and she is really focused on access to justice. So this is like an interesting conversation to sort of bring back to her, to me. Arbitration is a creature of contract, and you're absolutely right. Like we all sign these adhesion contracts for our cell phones where we're not negotiating a contract. We either like it's kind of take it or leave it. Like you either sign it or you're not. And the only place where you would really have control over that is going to be in a negotiated contract. So, I mean, you can put in all that language that you want it, the choice, you can put in your choice of law where you want it to be, all of those things in a negotiated contract. And, that's sort of the thing that we like about arbitration, right? Because but I think I also hear what you're saying, and it's true, like for the most of us, we're not sitting down and negotiating contracts with people, right? It's certain settings, and even if you're like going to buy a home, you're not really getting into a big negotiation with a bank, right? You're kind of signing the contract as it is. So it's definitely super imperfect, right? There's not.
But one way that you could address that, for example, would be the company lawyer and have a relationship with tribal courts. So that when you have a commercial agreement, you already have a relationship with tribal courts. Have commercial statutes and commercial codes and so forth to work through those. federal, through the state, UCC.
Definitely.
I think this is great feedback. Yeah.
It is.
Yeah,
For us
absolutely.
to take away. I mean,
Yeah, I really
it's a
appreciate it.
learning process. As Elizabeth says, it's not perfect. We don't have answers. I mean, certainly in mediation, you can more level the playing field of that power imbalance. You are not necessarily bound. Thank you. To the choice of law clause, to only recognizing state law and not tribal law. You are much more free to create a situation where all the interests are balanced and heard and come to a resolution. You are less free in arbitration. You're more free than being in court, but you can't just completely ignore the law as it's chosen in the contract, and it's difficult. Hopefully, we're helping people understand is going forward, to the extent you can negotiate contracts, and you can't always, as Elizabeth says, but to the extent you can, choosing tribal law, choosing your venue, choosing alternative, requiring mediation before you end up either filing in court or in arbitration, gives you some more power.
Well, thank you guys.
Yeah, thanks so much. This is
Really,
really
thoughtful,
great
interesting
information
questions.
sharing.
Really,
And
thank you so much.